Okay, it is the magic hour. Everybody, welcome to the Supreme Court panel hosted by the Law and Justice Department and Source. And I can tell you that all of us at the Law and Justice Department, faculty, students, are so thrilled to once again be back at Source. It's been 2 years since we were last here, and we've got some especially exciting presentations on Supreme Court cases that are currently before the court. And my hope is that you'll enjoy the presentations these students have worked so hard to prepare. A note on format, remembering that I've been asked to read something. A note to all presenters that there will be awards for outstanding oral presentations at Source. Awards will be made at noon on Thursday, June the 2nd in the Cirque Ballroom. Also, this session is being live streamed through Zoom so that students, faculty, and staff at all of our campuses and online can attend. So everybody be on your very best behavior. My name is Schaefer Claridge. I'm a senior lecturer in the Law and Justice Department, and I'm one of the lucky persons to have mentored some very fine students for this Supreme Court panel. Joined with me in mentoring are Professor Teresa Devine, who is coincidentally this year's recipient of the Distinguished Faculty for Service Award, and Dr. Cody Stoddard, our department chair. And finally, as I mentioned, me, the 5-time winner of Central Today's Best Hair. They always like that one. So a note on format. Each of our presentations will have, or each of our presenters will have 10 minutes to present. I will be monitoring their time and letting them know when they are short on time. We will follow that by a couple of minutes of questions and answers from judges, but also any person in attendance, and then we will move on to the next presentation. I ask, keeping in mind how nerve-wracking of a performance this can be, that you be sure to serenade our presenters with applause, both entering and leaving. Can the judges in the room please identify themselves? You now know who to complain to after the presentation. That said, our first presenter is Gabriel Diaz. His presentation, Qualified Immunity at What Cost? A round of applause for Gabriel Diaz, please. Good luck.
So down means
This one goes forward.
okay. Thank you. Hello, everyone. My name is Gabriel Diaz, and I will be presenting my presentation on qualified immunity and at what cost. So to begin, what is qualified immunity? Qualified immunity is a legal doctrine that was created to protect government officials from liability if they infringe on our constitutional rights. So what is the history of qualified immunity? It started out by the Civil Rights Act of 1781, which was also termed the Ku Klux Klan Act. But what is the Ku Klux Klan Act? The Ku Klux Klan Act was to protect the private right of action for individuals whose constitutional rights had been violated by police officers or other state officials. This act was put into place to protect the civil liberties and political rights of African Americans, especially after being freed from slavery. But how did this act protect African Americans? It allowed African Americans to challenge police misconduct from the racial terror they were facing. The Civil Rights Act of 1871 was codified under the 42 United States Code of 1983. So what did codifying this act do for the Civil Rights Act of 1871? Well, it allowed for private suits of action for damages done to any person. A person can be sued under this code if they acted upon under any color of statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia. So what does under of color mean? The under of color clause refers to when people misuse their authority, but this tends to fall for under police use of excessive force. In a Supreme Court case, Pearson versus Ruan, is where we first see the section of 1983 be applied to law enforcement officers. So what is the Supreme Court case of Pearson versus Ruan? This court case took place in 1967. A group of African Americans and their white counterparts were trying to promote racial integration at a segregated interbus state terminal waiting room. They were arrested and sued the officers and judges for false arrest and imprisonment. The Supreme Court took this case and granted the judge pure immunity, and the officers acted in good faith. Pearson versus Ruan was the start of the chain reaction that would soon follow. The courts would redefine what qualified immunity means and what we see today, which gets rid of the good faith basis and moves to a clearly established law standard. But what does clearly established law standard means? Clearly established law means that a law is sufficiently clear, every reasonable official would understand what he or she is doing is unlawful. So I want to take a moment and look at how good faith and qualified immunity can be both problematic in regards to police officers and their citizens regarding any situations. So I want to provide a real life example, but I'm going to say it as if you're in the situation. So let's imagine that you're walking home and there has been calls around the area that somebody is panhandling. So the officers are looking around, and of course you fit the descriptions, and the officers stop you to talk to you. You talk to the officers and you respond respectfully, giving them information of who you are. And I'm sure you're asking questions of why they are stopping you. But while you're talking to the officer, another officer comes right behind you and pins your arms to your side and asks to put your hands behind your back. But before you can even respond or even do what the officer is asking, he slams you to the ground in a matter of seconds, evidently breaking your wrist. And so you and the officers, the other officer comes back and talks to you and says that this person is not who they're looking for. They evidently got the wrong person. And so you refuse to go to an ambulance, and then you and the officers went on your way. But when we look at how good faith and the clearly established law standard, how would they interpret this interaction? Well, good faith was see as the officers were acting in a way that they saw was reasonable and authorized by law. A clearly established law would look at this and say the officers were not liable because during this incident, those rights were not clearly established at the time of the violation. So how is clearly established law more dangerous than the good faith basis? Good or bad faith is irrelevant when it comes to the clearly established law standard, which entails that no matter what an officer has done to infringe on your constitutional right, if there was no clearly established law, the officers are more likely to be granted immunity for what has happened. So a court case that I chose was City of Tahlequah, Oklahoma versus Austin P. Bound. It was, so some background information was August 12th, 2016 in the city of Tahlequah, Oklahoma. The police got a call from Joy explaining how her ex-husband, Dominic Gonzalez, was intoxicated in Joy's garage looking for his tools. When the officers entered the garage and spoke to Gonzalez was apprehensive due to him believing the officers were going to take him to jail for being in Joy's garage without her consent. While the officers were examining Gonzalez's behavior, they saw that Gonzalez was nervous and was fidgeting with things in his hands. Gonzalez faced towards Officer Gardner, appearing to throw a hammer or charging at them, and Officer Gardner and Vic fired their weapons at Gonzalez, killing him instantly. So the arguments for the court case and reasoning for petitioning for qualified immunity is the capacious Graham test conflicts with the Fourth Amendment test. The petitioners are entitled to summary of judgment on the merits and under qualified immunity. The petitioners are entitled to defend themselves from those who are trying to cause them harm. And reasons for denying the petition is petitioners weigh the review for the first question presented. Gonzalez was not a serious threat at any point with the encounter with the police. And the petitioners did not challenge the 10th Circuit's determination that Gonzalez was not a threat. And this case is not a circus split. So the Supreme Court decides that in the city of Tahlequah, Oklahoma versus Austin P. Bound, the court decides the officers did not violate Gonzalez's Fourth Amendment right, which means that the officers were granted immunity for killing Dominic Gonzalez. So issues with qualified immunity. Victims of police brutality would not be able to hold police officers accountable for their actions. And because police officers are not held accountable for their actions, we see little reform in changes in policies regarding police brutality and excessive force. It also shields officers who have used excessive force from any legal trouble, which pushes the public to be more apprehensive when it comes to the police. Qualified immunity is also can be biased towards police officers in questioning from those who have done excessive force. And the courts must see a clearly established law that has been violated. And all these issues make this doctrine terrifying when it comes to like us not trusting the police. We become more apprehensive with them and fearful when we're getting pulled over. Seeing all the violence on social media and officers getting away with it has made the public so weary. And I feel like the police should be trusted. We should be able to trust the police and rely on them to uphold our constitutional right, to protect the documents that had made this country. Qualified immunity is supposed to protect those officers from any liability, in which it has done. But what we really do see what qualified immunity is doing is protecting in almost every instant a police officer has done misconduct. And for example that we can talk about is like the Breonna Taylor case. So another course of action, and what I propose is that we can end qualified immunity doctrine. I know some would say that ending it would make people not want to become a police officer as they would feel more liable under situations that they have caused. But ending the doctrine doesn't mean anything about being more liable. We'll be able to hold police officers more accountable for misuse of authority and using police brutality and excessive force. We can also use only for certain situations to be under the doctrine and qualifying immunity. So an example of this is if police officers and a criminal are having a shootout and the police officers end up killing that criminal, that would be under the qualifying immunity as certain aspects would have happened. So we're not seeing it where police officers are slamming you to the ground or using police brutality and getting away with it. And we could also enforce officers to carry a liability insurance. And what I mean by this is every police officer would carry this insurance that would cover any property damage or any personal injury to a person that they have wrongdoing. Officers could also use this insurance when they're charged with a lawsuit from citizens. I feel as if we had the liability insurance, police officers would be less likely to cause harm to other people as they would be coming out of their own pockets. They do not want to waste their own money, and it would make people feel more safe. So that is the end of my presentation. I wanted to thank Professor Claridge for all the hard work he has done and just helping me throughout this entire thing. I want to thank the judges and Source for allowing me to have this opportunity. So thank you.
For a second. His torture not quite done. We move now to a question and answer session. Given that we are being streamed via Zoom, if you have a question, I will come to you so that you can ask it into the microphone. And a reminder to Gabriel, Diaz, and to all of our participants, it's entirely possible you'll get asked a question you don't know the answer to. That is okay. In fact, in an academic sense, the answers we don't yet have, the questions we don't yet have answers to are some of the most exciting academic moments. So don't let that put you off. That said, any questions? Here I come, Dr. Reasons, soon to leave us, which is why I'll indulge him by bringing him the microphone.
Excellent presentation, thank you. My only question is, you've laid out options. Which option do you believe we should follow?
A dangerous question, but an answer I am also interested in.
Thank you. Well, that is an amazing question, and thank you for that. I feel like maybe instead of, I don't think we should abolish the entire thing. I feel like if we had the carry liability insurance, that would make sure that every police officer is held accountable, and so we still have qualified immunity. So only certain situations, cops would not be held to prosecute for those things. So like, let's say they end qualified immunity, would that mean that police officers who were being just worthy of their actions, would that mean that they would go be prosecuted because of that? I feel like if we had the insurance, that would be a more better way for officers to be able to have that authority, but not also use that authority to their own power.
Other questions?
Thank you for the presentation. In your reasons to reject, maybe it was, one of them was the petitioner's waived review for the first question. Can you explain what that means?
And thank you for the question. So the courts in the documents, it talked about the Katori, like why they should, I cannot pronounce the word, but I hope that everybody understands. But it basically means that that word is a writ or order by which a higher court reviews a decision of a lower court. So the people who are denied or trying to have a reason for that, they have waived that question from review.
Here I come.
So I know a lot of people from previous classes, one of the reasons that this type of doctrine exists is to make the officers feel protected by their employer. So for the liability, I think it's a good idea. What if the employer, or so the department or the state, are the ones who are insuring the officers for them? So then they're still protected by their employer and they're still protected by the state, but in a different way where they're still open for people to challenge whether or not their rights have been violated.
Do you understand the question? Okay.
Thank you. And again, thank you for the question. I think you have an excellent point. I feel like in a way, with having insurance, I feel like there can be a small percentage taken out of a police officer's paycheck. So with my job, I have state insurance, and it comes a little bit out of my paycheck each month. So I'm still putting money into that insurance. But I do believe with them having some coverage from the state, and it maybe they pay more than half of it, it will give police officers, feeling protected from the state. So yeah.
Okay, we've got one last question, then we'll be releasing Mr. Diaz.
Excellent work. Thank you so much. As far as your suggestions for qualified immunity, would you want to see those implemented at the state level or the federal level?
Another great question. Thank you so much. I would like to see it at a federal level. I mean, we have this talk that states get to choose whatever they want, but if we implement it at a federal level, that means we're going to see less police misconduct. We're going to see police officers being less, using that authority to their own power. So we have it at the federal level. I think it would help a lot more.
Thank you for the excellent questions. A second and final round of applause for Gabriel Diaz. I've been asked to ensure that we tarry somewhat in order to allow persons who are showing up to support the presenters to get here at the appropriate time. So we'll spend a couple of minutes wasting time, either by telling jokes or juggling, or maybe talking about the content. For the judges and for the participants, the students select Supreme Court cases that are before the court this year. For we academics who study the court, even we don't know exactly when Supreme Court opinions will be released. So some of these presenters have opinions that already have come out. We know what the court has done. Others have cases that are still not yet decided, although they've been argued. So we're waiting to see what might happen. Others, like our next presenter, have cases that have not yet been decided, but draft opinions have been leaked and their authenticity confirmed. So for the judges especially, there's an imperfect science in selecting these cases, and whether or not we have a decision really comes down to luck more than anything else. That said, we can go ahead and call to the stage our next presenter, Rachael Medalia. Round of applause for Rachael Medalia. And her presentation, United States v. Texas et al. 2022.
I'm just gonna test them out really quick. All right, welcome everybody. Thank you so much for being here with us today. My name is Rachael Medalia. I'm one of the current law and justice students here at Central Washington University. I'm really excited to be here with y'all today. We just had an awesome presentation before us, so I'm a little bit nervous because that one was really good. Thank you. Okay, so I'm going to be going over, oh my goodness, that's fun. I'm going to be going over a couple of different cases. So I'm starting off here with United States v. Texas et al. 2022. Now, I'm a super involved student, as many of you that might know me already know. I'm incoming university president or student president for next year. I'm involved as a TA. I see some of you guys that are in the class that I TA for. So I'm doing a lot of stuff. So of course, leave it up to me to pick a case that is intertwined with two other cases in the Supreme Court. So not only am I going to be talking about United States v. Texas, I'll also be talking about, where is it? Dobbs v. Jackson and Jackson v. Women's Health 2022 and Dobbs v. Jackson 2022. So have fun keeping those two names straight because they are very similar. We'll go ahead and move on. So in my introduction today, I'll show you guys, we're going to start off with some of the background cases that give light and give breadth to the Supreme Court cases that came up this year. We'll start with Roe, and then we'll go over Casey, which is more of the controlling law on abortion. And then we'll move on to Texas Senate Bill 8, which is the law that Whole Woman's Health v. Jackson caused to be brought up. And then we'll go over the Gestational Age Act, which caused Dobbs v. Jackson Women's Health to be brought up. And then finally, we'll end with the implications here of both Whole Woman's Health v. Jackson and Dobbs v. Jackson Women's Health. Again, this case and the following cases are about abortion. So please be respectful of everyone around you. This is an educational environment. We're all here to be supportive and to learn. So again, please be respectful. So we'll move on to the history, and we're beginning now with Roe v. Wade. So Roe v. Wade starts off in 1973 in Texas. Jane Roe is the name that was given to one of the litigants in this case to keep her identity hidden. This case was suing Jane Roe against Henry Wade, the district attorney of Dallas County, Texas. Eventually, her case was appealed up to the Supreme Court, and the Supreme Court ruled in a 7-2 vote that unduly restrictive state regulation of abortion is unconstitutional based on the privacy rights that are implicit in the 14th Amendment. The Supreme Court did not, however, agree with Roe's assertion of abortion being legal anytime and in any method. They attempted to balance the rights of individual privacy under the 14th Amendment and the state rights to create laws in this area. The precedent set in Roe has been repeatedly challenged with new cases, but none have overturned it yet. And the Supreme Court in this case set a standard of viability, which is about at 24 weeks. So we'll move forward. This is an important quote from Roe v. Wade that is relevant to some of the other case law that we'll be talking about today. Only a compelling state interest justifies regulations limiting fundamental rights, such as privacy, and legislators must therefore draw statutes narrowly to express only the legitimate state interests at stake. So next we'll move on to Planned Parenthood v. Casey. In 1988 and 1989 in Southern Pennsylvania, Governor Robert Casey and the Pennsylvania Commonwealth created several laws that were regulating abortion. One of them was that women had to inform their husbands before getting an abortion. This case generated a plurality opinion, which means that the court essentially believed both litigants were somewhat correct, but it still reaffirmed the principles in Roe. However, this opinion reframed that trimester-based system, that 24 weeks, that Roe created and allowed states to create a more flexible definition of viability. The judgment also revised the test that the court used to scrutinize laws relating to abortion and moving to the undue burden standard, which says that a law is invalid if its purpose affects its place to substantial place substantial obstacles in the path of a woman seeking an abortion before the fetus attains viability. Now we'll move on to Texas Senate Bill 8, which is the law that caused both United States v. Texas and a couple of other cases to be brought up. So in May of 21, Texas adopted Senate Bill 8, which was a very interesting legal mechanism. This is a new legal mechanism that had not been heard of prior to the state that allows private citizens to sue other people in this case. So it's not a criminal law that this is affecting. So this law targets anyone that helps women or uterus havers to get an abortion, right? So it could be the taxi cab driver. It could be the person performing the abortion. It could be anyone that knew about it and helped it happen, right? So this bill involves that critical legal mechanism to avoid triggering the 14th Amendment right to privacy. So we'll go ahead and move on. Here is a little graphic that I created for y'all that shows those first 6 weeks of pregnancy that are relevant to this bill. Down here, you'll see the window for Texas Senate Bill 8. This bill is often called the fetal heartbeat bill because it targets abortions that are performed anytime after a fetal heartbeat can be detected within this range. You will also notice that the positive pregnancy tests are not going to start showing up until right here at the beginning of week 5. So you could have a fetal heartbeat on the same day that your pregnancy test first shows up as positive. So something to note. All right. So this is the Supreme Court case, the two of them that came from the law that I just talked about, Senate Bill 8. Whole Woman's Health v. Jackson and United States v. Texas. 2 days after Senate Bill 8 was to take effect, or 2 days before, sorry, Senate Bill 8 was to take effect, a group of abortion providers in Texas called Whole Woman's Health filed an emergency request with the Supreme Court asking that they block the enforcement of the law or vacate an appeals court ruling that had halted the litigation of Whole Woman's Health challenge in federal district court. After 3 days, the court had a majority vote of 5-4 and decided not to be involved yet, but also stressed that this didn't mean that they were putting out an opinion, just that they were not going to review the case quite yet. After the Supreme Court denied the emergency request to vacate the appeal, allowing Texas Senate Bill 8 to go into effect, the federal government filed suit against the state of Texas, which became United States v. Texas. In November, the court agreed to an expedited review of both cases on 2 closely related questions: whether a state can prevent federal court review of a state law by delegating its enforcement to the general public, and whether the federal government can bring suit in federal court against Texas state officials and all private citizens to prohibit enforcement of Senate Bill 8. On December 10th, 2021, the court dismissed United States v. Texas and ruled that the plaintiffs in Whole Woman's Health v. Jackson could pursue a challenge in SB 8 in federal court against members of the government, but declined to join legal action regarding the case. So the question moving forward in the next case that we're going to talk about is, are all state prohibitions of elective abortions performed before the point of fetal viability unconstitutional? So think about that question as we review this next case. This case began with the Gestational Age Act in Mississippi in 2018. The Mississippi legislature was attempting to pass this law multiple times before it eventually did in 2018. And this banned any abortion operation after the 15th week of pregnancy, with exceptions for medical emergency. Now, Dobbs v. Jackson, or Dobbs v. Jackson Women's Health, is the court case that came out of that law. The Gestational Age Act sparks Dobbs v. Jackson Women's Health. On the day that that act was supposed to go into effect, Jackson Women's Health Organization, which was the only licensed clinic in Mississippi, filed a federal suit in district court challenging the constitutionality of the law. This was escalated up to the Supreme Court in May of 2021 to review the case. And this is the case that got leaked. So y'all might already know a little bit about this one. The Supreme Court was expected to issue a decision in this case around the 21-22 term, which ends usually in June. In May of 22, however, an apparent draft of that majority opinion was leaked to a political news organization. And that was a serious breach of the court's typical privacy. The opinion, dated in February of 2022, had a vote to overturn both Roe v. Wade and Planned Parenthood v. Casey in this case. So let's talk about some of the implications of these cases. First, we'll talk about Whole Woman's Health v. Jackson, because this one is slightly more relevant than United States v. Texas, as it is more likely to have another similar case come up related to it. So the first important thing to know about Senate Bill 8 is that it's at somewhat of a stalemate now. The abortion rates are lower in Texas. People have not yet been getting sued for this, but this mechanism doesn't have to be litigated for it to be effective. This mechanism creates what's called a chilling effect. So people will be scared now to get abortions or to help someone get an abortion out of fear of being prosecuted. You don't have to punish someone if your threat is good enough. It's also likely that this mechanism will be undone. This legal mechanism associated with Texas Senate Bill 8 avoids the spirit of the law. It violates common law, which is how case law works in the United States. And the Supreme Court might have kicked down Whole Woman's Health v. Jackson to the lower courts to think about it more. But as soon as a case comes up where someone is suing another for aiding and abetting in Texas, that's going to get escalated up to the Supreme Court. And it's likely that they will probably do something with this mechanism. The last big implication is a national possibility of a replication of this legal mechanism. So it doesn't necessarily have to just be abortion. Governor Newsom of California is super into gun laws, for example. So you might see this same mechanism replicated in places like California with gun laws or anywhere else in the country. It's also likely that this mechanism is going to be replicated in many other states, and the Supreme Court might have to deal with it, not necessarily from Texas, but from another statute. Okay, moving on to Dobbs v. Jackson and those implications. One of the obvious ones is that Roe v. Wade and Casey are probably going to be overturned. Many states have something called a trigger law related to abortion. So that means that as soon as Roe v. Wade and Casey are ever overturned, that those states are going to be able to put their litigation into place right away. It's already set up, it's ready to go, and they're going to start making abortion illegal at varying degrees as soon as that is released. There's also some concerning implications for the Supreme Court overturning 40 years of precedent. There will be need to go over new litigation and to decide the rules of Roe v. Wade after Casey and Roe are overturned. This case will change the way that we think about privacy rights as well. Consider the impact that this decision will have on the social capital of the Supreme Court as well. Will this affect the decisions of the Supreme Court in the future? Thank you, guys.
As Ms. Medalia noted, this is an issue that I'm sure many people in the room care very deeply about. And talking about difficult things at college is the reason we're here, and also presents a very serious risk of people being made to relive traumas or live out future fears. That said, I encourage questions. And when you ask a question, please bear in mind that for you, what might be hypothetical for other people in the room is a lived experience. That said, I'm sure many people are excited. So are there any questions for Ms. Medalia?
Great presentation. You did an amazing job. So my question is, if they do overturn, I mean, it looks like it's going to be overturned Roe versus Wade and Planned versus Casey. Do you think any other privacy laws are going to be affected if that does happen? And which ones do you think could happen?
Yeah, absolutely. Great question. Thank you. So this does open up the possibility for other privacy rights that had happened after Roe v. Wade to be changed. So I don't necessarily think that it's likely that things like gay marriage are going to be changed. I don't think it's likely that those things are going to be changed, those privacy rights, but it is possible. That door is wide open now. I do think that Roe is going to be overturned, especially based on that opinion that was leaked. I think that it's going to be less intense than the draft was when they do finally release that opinion. But again, it does open up that door for a lot of different cases. I mean, all different types of marriage, certain adoption laws, a lot of that stuff is guaranteed and protected under those privacy rights. So thank you. Good question.
Others? I'll defer first to our judge before turning to Ms. Brown.
Possibly a silly hypothetical. Texas SB 8, if I understood your slide correctly, forbids abortion after detection of fetal heartbeat. So if you don't bother trying to detect it, is abortion allowed?
Another excellent question. Thank you. So there is something called plausible deniability, which means that if you reasonably might not have known, you can deny it. But at a certain point, like after that 6 weeks is up, it is going to be kind of difficult to deny that. That's why it is typically centered around that 5th and 6th week. So it's called the heartbeat bill, and it's supposed to be based off of the heartbeat. But again, if it's after that 6 weeks, I doubt that there's going to be a lot of people that are able to argue their way out of that. Yeah, thank you. Good question.
As promised, Ms. Brown.
Hello, Rachel. Love the presentation today. I rolled in a little late, but I was curious about what the implications of Planned Parenthood versus Casey being overturned. What would happen if that does happen?
Thank you, Peyton. So a couple of different things are going to be up for being redefined after Casey is overturned. Some of the things that I talked about in the presentation actually are that there's going to need to be a new set of rules about abortion. So right now, as soon as Roe and Casey are overturned, it's going to be allowed up to the states to decide, but it's opening up the door now for another Supreme Court case to redefine whether the Supreme Court wants to have any rules about abortion in the future. Thank you.
The chat, as the kids say, is blowing up, so I want to make sure that okay. Are there multiple questions?
There's one question.
Okay.
So Mason said Rachel did absolutely amazing. Melia said great job. Olivia said she did so good. Mason also has a question. Do you think that we are likely to see challenges to other marriage statutes? For example, Senator Mike Braun, Indiana, has said that he wants to overturn interracial marriage. Do you believe they can now do this? And thank you again and keep up the amazing work.
We will strike the Rachel is awesome comments under the 404 prohibition of character evidence, but the question can stand.
Thank you, Mason, and thank you for reading. So Mason asked a really good question, which I think is reflective of some of the questions that we've had already. I do think that interracial marriage could be up for grabs. Again, I don't think it's necessarily likely that states are going to be able to overturn that. I do think that there's going to be a lot of resistance to things like that. And I'm not sure necessarily that the Supreme Court has the stomach to go after those things. So you might see it on the state level, but I particularly am not sure if the Supreme Court is going to be going after things after Roe v. Wade has been overturned.
Okay.
This question is from Olivia. Olivia says, if/when Roe gets overturned, how soon do you think new abortion precedent will be created? Thank you, Rachel.
Yes, another really good question. Thank you from Olivia. So it kind of depends. It depends on how it is escalated up and where this law comes from. So if it is Supreme Court case law, we could see someone that needed to get an abortion did so and then was prosecuted for it in their state. And then you might see that get escalated up to the Supreme Court. And at that point, I think you might see the Supreme Court creating new laws and new regulations after Roe was overturned, which previously did have the 24 weeks and then a couple of different viability standards. Thank you.
We'll take one more question from Mr. Hodges. I don't mean to cut the questions off prematurely, so keep in mind that upon the conclusion of the panel, you are absolutely welcome to come talk to any of our panelists about additional questions you may have.
So about the Texas heartbeat bill, do you know how specifically they say what a heartbeat is? Is it something just like electrical activity without necessarily the circulation of blood, or is it the circulation of blood within the fetus? Do you know where they draw that line?
Thank you for that question. I'm going to start by saying that I am not a medical expert and that this is just my understanding of it. But from my understanding, there is a way that you can go into your doctor or your primary care provider and they literally can do something similar to an ultrasound and are able to detect that fetal heartbeat. I could be wrong on that, so don't quote me. But I encourage you to check that out in the future. I have in some of my sources a couple of different places that might be able to answer your question. Thank you.
Another round of applause for Rachael Medalia. Okay, so we have a interesting gap in our schedule. We had a couple of participants drop out. Rather than sit here for the next 30 minutes, I'll be independently conferring with each of the panelists to see whether or not they are ready to go now. Our next panelist is, but for persons who are scheduled yet to come, I promise we won't make you go before you're ready and your friends and family are here. So you'll be able to make those determinations independently. Apologies again to my judges, who I entirely forgot to ask whether they were ready for the next presenter to begin. It's my first time in a while, and I'm nervous, much like these panelists are, though they are managing their nerves far better than I. So, judges, would we be ready to move on? Okay. So, waiting awkwardly as I ascend the stairs, our next presentation will be from Emily Chavez, Garland v. Gonzalez, the truth about the American dream. A round of applause for Ms. Chavez.
Thank you. Hello, everyone. My name is Emily Chavez. I want to thank everyone for being here today. Also, my mentor, Professor Robert Claridge, for allowing me this opportunity to be here, as well as all the judges who came here and are helping me present this as well. This case is about Garland versus Gonzalez, a Supreme Court case set to be heard of June of 2023. This case is about Esteban Aleman Gonzalez and Jose Eduardo Gutierrez Sanchez, who are both natives and citizens of Mexico, but are currently reside within a detention center here in the United States. Currently, they have been detained because of their re-entry back into the United States. They have both previously come into the United States, been deported, and have come back due to the fact that they are both seeking asylum within the United States due to the fear of persecution in Mexico. Gonzalez, who has become a target of the Zetas drug cartel, and Sanchez, who has also become a target of organized crime due to his sexuality.
Both of them are currently asking for asylum here in the United States, but have been withheld with over 180 days. The plaintiffs of this case are trying to pursue a withholding-only proceeding to be granted citizenship with here in the United States, as well as a work permit. Even with this information, it is hard to decipher when they'll be heard in front of a jury and are questioning whether they will be presented within the 6 months. A very important statute that is presented to people here in the United States is the Immigration Reform and Responsibility Act of 1996. This act promises all immigrants here in the United States who come here fleeing from their home countries, promising them to be heard within 6 months within their immigration statute. So it basically explains that due to the statute, they're entitled by law to be heard within an immigration judge before 6 months. On January 11th of 2022, the Supreme Court asked a very specific question. That was whether a non-citizen who has spent more than 6 months in an immigration detention awaiting resolution of their deportation withholding claim entitled to be heard in front of an immigration judge to determine if they can be released on bond. Some information that was presented within this case is very important is that both of these immigrants here that have come to the United States have passed all preliminary testing, which means that due to they have passed all screenings that would allow them to be safe within the United States. They present no danger. They're no danger to society, as well have passed all exceeding initial screenings to be able to be stayed in the United States. But even with this information, it's hard to decipher when they'll be heard in front of an immigration attorney. Some arguments that are presented from the respondent's brief talk about the due process law. As everyone knows, the due process law protects our rights here in the United States. This due process protects that all immigrants and citizens and non-citizens alike are protected by this law, which would guarantee for them to be heard in front of an immigration judge prior to a set agenda. The petitioner's brief also speaks about the due process law, a very special component, section 1231 A and B. Within this component, it speaks about the due process. And yes, while it protects both non-citizens and citizens alike, it is hard to say that even with the detention process, it is a very valid point here in the United States. And detention is very necessary in order to bring people here in the United States. There needs to be a lot of screening. So this could take a very long time, which is a reason they're giving for why this is taking so long. The amicus brief that's given by Christopher J. Hayakin, he also talks about the due process law and explains that this could have a huge impact within the citizens, but it's hard to decipher yet again. A very important component that he brought up is a case that we are currently cross-examining within this case. It's case of Chavez. It's about also a citizen here who lost his citizenship due to a conviction, but due to the due process, he was able to be protected and was granted to be heard in front of a jury within 6 months. But even with this information, it's hard to say if the plaintiffs within this case are in the same jurisdiction currently, because they're no longer immigrants, but aliens due to the fact that they have already been ordered removal out of this country. Another information that was brought up was COVID-19 could have a huge serious impact within this case. As everyone knows, the government shut down for 2 years. So this has, while the entire government has shut down, the immigrants continue to come in these detention centers. So the government is starting to explain that, yes, that is why it's taking so long, because of the increase of people within the United States. The justices within this case, Justice Alito is explaining that because of their illegal reentry back into the United States, it might have posed a challenge for them to be guaranteed citizenship here, as well as guaranteed even to a works permit here in the United States. Justice Gorsuch also explains that even with the amount of cases that they're starting to bring in, it's also hard to determine when they'll be heard because there are so many people awaiting to be heard in front of immigration judges. Both President Biden and former President Trump have both guaranteed that the detention process is a very important part within the immigration process here in the United States. However, even with all Supreme Court cases, it's important to know what kind of violations this bring against our own amendment rights. This Supreme Court case brings problems within our Fifth Amendment and our due process clause within the United States. As everyone knows, everyone who has been incarcerated has the right to be heard of an immigration judge. This is a very important aspect within our own liberties here in the United States, even if you're not a citizen here. Okay, so there's some issues that are being posed within this case is also commemorates with human rights of every person in the United States. Whereas we're seeing here, there has been a huge income of immigrants in the United States. 250,000 people came into the United States in 2021. That is 20,000 people within one detention center. That is almost $3 billion that the United States is spending within each detention center. Even with the amount of money and even with this increase of people, there are still so many issues within this detention process. For example, less than 7% are heard within 6 months. Less than 12% are heard 6 months, which is what is guaranteed for all non-citizens and citizens here in the United States. As everyone can see here, half of the people within these detention centers, which is 10,000 to 12,000 people, wait 2 to 4 years before they're even heard in front of an immigration judge. Within these detention centers, there's a lot of issues, not only to amendment rights, but to our human rights within the United States. For example, here, we're starting to see a lot of health issues, nutritional issues, prolonged detentions, physical issues. These detention centers are not what they seem, and a lot of people don't normally know what happens within these detention centers. The reality within these detention centers are this. And as everyone can see, that is not what we promise people, even who are convicted of serious felony crimes. We promise that people are coming to the United States and that this is something the government has already allowed for people to do because they've set up a lot of statutes for these people, guaranteeing that they can come here for support and asylum from their home countries. But this is what they get in return. There is 20, as you can see, there's 20,000 people. So most of the people are just stand in cages like this. They sleep together in little tissue papers. There's children within these detention centers. So my question is, why do we allow for within prisons for them to authorize jobs, for them to have opportunities to go to school, for them to have opportunities to have animals within their jail cells, but the people that we promise here a second chance receive this? So while I personally don't agree with what is going to happen, I do think that the case is going to agree with petitioners. Oops, sorry. They are agreeing with the petitioners just due to the fact that it's hard for the government to promise 20,000 people within each detention centers. That's 250,000 people just within 2021 to be heard in front of an immigration judge. For them to promise that, it's nearly impossible, even though it is what the law says that it's supposed to happen. It's nearly impossible to guarantee all these people. They would have to begin with the people that have already been waiting 2 to 4 years. They have to begin with the people who have already waited 4 years to even be heard. In order for this process to happen, it's going to even take 4 more years for the people who are at the beginning of the line at the moment. However, the importance of this case is people now know what's happening, you know? It's important for everyone to know what is happening in detention centers, and hopefully we can make a change. Maybe we can have more immigration juries be able to provide more jobs for those people who are willing to hear more of those cases down in the detention centers. We can provide more jobs that way. But my biggest takeaway from this case is I want people to know that most of these families leave absolutely everything behind. Most of these people leave everything just for the small guarantee that they'll be able to be promised here a life in the United States. And the thing is, many of these people don't get to say goodbye to the family members, don't have contact with their family members until they're in the United States. So that is 2 to 4 years that family members might not be able to hear from their families. So I want you guys all to think about this, that most of those people leave everything behind just to have the slim chance of getting the life that we all have here. Thank you.
Questions for Ms. Chavez?
Thank you. Awesome job. That was really excellent. My question is, do you think that having government facilities where people are being kept versus private facilities that the government has a contract with has an impact on the treatment of people inside these detention centers?
Thank you. That's a good question. Honestly, I think so. Just because having the government have authority over these places would allow for a better situation. As I was explaining, most prisons that are controlled by the government officials, they allow for jobs and GED programs. And I mean, people who come into the United States aren't coming for that programs within these places. You know, they want to be able to have a life here in the United States. So I think that at least having the government take control over what happens in these detention centers could pose less threats to their human rights within these detention centers. Maybe more promises, maybe an actual room for every family, better food, and honestly, just anything rather than 20 people within a cage would be better, 100%.
Thank you. Coming to you, Mr. Hernandez.
So not talking about the detention centers themselves, just the fact that so many people are having to wait so long to see the immigration judge. Do you think that is more on part just because our court systems are backed up extremely and super busy? Or do you think it's our government kind of ignoring this issue and kind of sidestepping this issue and not giving it as much thought and care as it should?
Thank you. That's a good question. Honestly, both. The government has already put out, the Supreme Court has previously already said that all people who come into the United States are to be guaranteed within to be guaranteed in front of a judge within 6 months. There's already statutes in place. So I think that the government, it's hard for the government to bring out all these statutes, all these amendments, and basically say, yeah, you're protected here. But then once they're here, they're like, well, it's taking a long time. So, I mean, COVID did slow everything down, and all the courts are really backed up. Even here in every state and federally, they are backed up. But it's hard for them to guarantee this and then also not make that happen. You know, if they're going to put out statutes, the Supreme Court can already decide on this, then it should happen.
Other questions?
Excellent presentation. I just want to point out and mention that the government, of course, is saying that they aren't incarcerated. They're detained, so they don't have basic minimal civil rights of inmates, like no quote normal criminal inmates, even though via criminal, crimmigration, the civil is turned into criminal. So, it's a big facade, and the private prison industry, really, detention industry, is the main winner in this, if you will. Do you see, again, you're the expert here, do you see that reversing? Do you see under the Biden administration maybe changes which may be more reasonable?
Thank you. That's a really good question. Honestly, I mean, the Biden administration did open up the borders. So due to this administration, he's already promised people the opportunity to come into the United States and then to hopefully one day be able to be out in the United States. So I hope that now that he has allowed this opportunity, that maybe they'll be able to be like, well, we can't just keep 20,000 people within this detention centers. We got to start moving them out. I mean, if we're looking at future tense, if 20,000 people continue to be in this place, it's been 6 to 7 years, it's just going to end in riots. I mean, how long does a human have to stay in situations like that before they finally crack? So, I mean, either the Biden administration is going to have to make more jobs and be able to speed up the process, or they're going to have to deal with the issue once it finally explodes. Thank you.
Other questions?
You did amazing on your presentation. Just want to say that, so good job. I know in the first, the title slide, you said American dream is a lie. And I know the American dream has been instilled into our American ideals. So my question to you is, what do you think as a society to become more self-aware about immigration? What do you think that we can do about that?
Thank you. I appreciate that a lot. Honestly, I've thought about this a lot, and I'm like, well, what can we do? And I was in my room and I was thinking, I'm like, I can't really do anything about the issue at the moment, but I guess if we were able to maybe provide more sanctions or like be able to find a way for the process to be sped up and allow the people who are already wanting to go back to Mexico because they can't withstand in these detention centers, allow them to go back. And then maybe within our within the states, we can find a way to provide help for them, maybe more jobs or the jobs that we do need, maybe have people who are in those detention centers, provide them with areas to do so. I've already seen that there's like a program here in Ellensburg as well. I think they come from Yakima, where many immigrants they're brought in trucks and they're able to work here in the Ellensburg and in the Yakima County. If we can do that all through the country, I mean, we would be able to speed up a lot. We would be able to get society kind of back in order, as well as providing sanction and jobs to those people who are in the detention centers.
Mr. Hernandez will be our last question for Ms. Chavez.
Would you say that if or just overall, that instead of keeping these people in detention centers or sending them back to where they came from and saying, okay, we'll try again later when we might have more time, if we let them out and just say, okay, go work, go do whatever, go start your new life, but then eventually we're going to need you to come back because we're going to need to talk to you in front of a trial or in front of a judge, do you think that would solve some of our issues? Or do you think we would still kind of be in this awkward place where we have a lot of people just waiting and waiting?
Thank you. Honestly, I think that would actually help a lot. Just allowing people to be able to have a good start without having to be within these detention centers could allow for them to kind of get settled here in the United States, but also for less frustration for all immigrants. And also it would provide this that huge problem of human rights of these detention process. The detention process is starting to pertain. We can start eliminating that by allowing people to kind of get head start. I mean, if the government was initially were to promise everyone that they were able to do that, I think that a lot of people would be willing to come back and come back to the cases, just because if respect is given, respect will be given back. That's how I feel.
Thank you. Another round of applause for Emily Chavez. Okay, I'll pause to allow the judges to finish whatever thoughts they may have. Next on our schedule is Dawson Greenleaf. Do you have are you ready to go now, or would you prefer to wait? Let's take a 5-minute. We've got wonderful thoughts to digest. Stick around if you are able. If not, feel free to go refresh yourself. We will reconvene in 5 minutes time. And if we've got people, panelists, feel free to go greet and thank your guests who are here supporting you. 5 minutes, everybody, 5 minutes.
All right, yeah, I'll try this.
Okay, everybody, be seated. I hope you enjoyed your break. It's work time now. Next up, we have Mr. Dawson Greenleaf presenting New York State Rifle and Pistol Association, Inc. v. Ruan. Protect me, protect my guns. A round of applause enthusiastically for Mr. Greenleaf.
Awesome. Thank you. Thank you, everyone, for being here. So, as a professor just said, the presentation I'll be giving is Protect Me, Protect My Guns, New York State Rifle and Pistol Association Incorporation v. Ruan. So this case is going to revolve heavily on the Second Amendment. So it's important to understand the components of the Second Amendment. The Second Amendment has two parts. Its prefatory clause and its operative clause. Its prefatory clause refers to a well-regulated militia being necessary for the security of a free state, and its operative clause referring to the right of a person to keep and bear arms shall not be infringed. Now, with this case and many other cases that argue for Second Amendment and self-defense, they focus in on that operative cause, the right of the person to keep and bear arms. So with that in mind, let's talk about the facts of the case. So New York State Rifle and Pistol Association had two members, Brandon Kosh and Robert Nash. They both applied for unrestricted concealed carry licenses in the state of New York. After submitting their applications, a licensing officer by the name of Richard McNally reviewed their applications and deemed that they didn't meet one of their requirements. With that, he instead gave both members general concealed carry licenses that referred to target shooting and hunting. With that, both Kosh and Nash sued, felt that this violated their Second Amendment, and here we are now at the Supreme Court. And if you look, this would be an example of what you'd see when applying for a concealed carry license. This is for the state of Wisconsin, but it has the generic submission application. So let's look at the law in question. So New York Penal Law, Section 400 poses objective requirements, things that other states also consider. The age has to be 21. You can't have a criminal history in terms of felonies, as well as you can't have a history of mental illness. But in New York, it's a may issue state. So they actually ask for one more requirement, a submission of cause. So a submission of, in this case, proper cause. And in proper cause was defined to the petitioners, in this case, Nash and Kosh, as an atypical nature. So in this case, they applied under self-defense. That was their reason for needing one. They had seen recent crime increase and they wanted to apply as a proactive measure in their town. So let's more in depth, because proper cause is going to be what the court is going to be looking at when defining. So proper cause, as defined in pure legislature, is a special need for self-protection, distinguishable from that of the general community or of persons of the same profession. So in other words, as previously said, an atypical nature for needing or possessing a firearm. Some of the more blatant examples that you could take away would be state judges, retired police officers for the state of New York, as well as unique individuals such as residents of New York who are high profile or important, quote unquote, important citizens. However, all of this is discretionary to the licensing officer looking at the application. So the question the court is tackling. Now is whether the state's denial of the petitioner's application for concealed carry licenses for self-defense violates the Second Amendment. And with that, they're considering our past in gun regulation and gun ownership, as well as what defines atypical and normal, what defines a law-abiding citizen and not. And lastly, what this precedent will set in terms of future gun legislation as it relates to concealed carry firearms. So the arguments being made by Kosh and Nash, as you see in that graph, this is stats of New York Police Department's crime ratio. And in January 2021 to January of 2022, they saw an overall increase in 38.5% of all overall crimes. So with that, they claimed that in their argument, as well as the discretionary capabilities of the licensing officer to look at a submission of proper cause and distinguishably or discretionally see if it suffices or not, as well as the discretion that the licensing officer has puts into effect a lack of a standard. If one licensing officer sees self-defense as a proper cause and one doesn't, where is the standard to be set? And then arguments for the state of New York, they're saying that they understand that residents have the right to keep and bear arms, but that right has never been unlimited. There have always been restrictions on what you can and cannot have as a firearm. For the sake of an example, bump stocks, those are now completely banned. There's a reason for that. There's already been, examples of why there needs to be regulations for this type of, for this case, firearms. As well as we'll talk later in the precedents, previous precedent, is the defense of within the home is different than the defense outside of the home. In that we have precedent set for defense within the home, but there has been nothing said about defense outside of the home. And this is why this case will bring that into question. And then lastly, with a more shall issue, because as said previously, New York State is a may issue. They require that proper cause. Places like Washington are shall issue, where it's open carry and you're not as required to take classes like in the state of New York. So with that, the may issue, if they switch to a shall issue, you're going to see an overall increase in concealed firearm carries, statistically speaking. And with that, that proliferates a likelihood of firearms injuries and deaths. So the previous precedent set. So previous to this case was a case in 2008 of District of Columbia v. Heller. This was the last big Second Amendment case that the Supreme Court held and voted on. And with that, the respondent Heller applied for a handgun for the defense of his home and was denied, later sued and took it to District of Columbia Circuit. And with that, the court found that the Second Amendment guarantees an individual's right to firearms for traditionally lawful purposes, including self-defense within the home. So as I said, with self-defense within the home, we are now going to define self-defense outside the home in this court, in this case. So the implications for caution ash, if the state or if the court finds the state's denial of their applications violated their Second Amendment. One of the big things you'll see is a increase in concealed carry licenses overall statewide. With that, states such as New Jersey, Rhode Island, California, who have may issue legislation, those states will have to change their regulations and move to a more shall issue. And with that, you're going to see law enforcement dealing with citizens in citizen interactions who may or may not have a concealed carry firearm on them. So it's a safety issue. So it needs to be addressed and concern, and it raises a concern. And then implications if the court finds that the state was well within their right to deny the applications under it didn't violate the Second Amendment. Well, short term, you won't see much change because states have already put in this legislation. And with that, the state won't change what it has already in place. So Rhode Island, New Jersey, California, the states that I've mentioned that are already may issue are just going to stay with their current legislation. However, if it does, in the long term is where you see a more quote unquote dramatic change, because now this will be the new precedent set. It's been over a decade since a Second Amendment case has been set since the 2008 case. So this will now bring a long-term effect for what the state has in terms of regulating your Second Amendment, as well as other amendments in regards to local flexibility of the state. And with that, I thank you all for listening, and I'm here for questions. Absolutely. Thank you.
Are there any questions?
Thank you very much. That was a great presentation. My question is, you brought up discretion a lot, and we see that being an issue a lot in law and justice. Do you think that addressing the discretionary breadth of maybe the people that do the licensing would be a solution, or at least help with the situation, since they seem to have so much influence on whether or not these people get licensed?
Thank you for the question. So hopefully I understand that question properly, but just as you said, discretion is a big issue for all cases for this matter, but in particularly the concealed carry. If a licensing officer can discretionally go, self-defense is or is not a viable proper cause or reason for needing a concealed carry license, especially with what the petitioners were arguing for in terms of recent crime increase. If they find that, and that's why I think this case is important, is if you set a standard for what is and is not suffice or a reasonable proper cause, then you're gonna always have the licensing officers that go, well, this person, depending on how they filled out, because we're only talking about just the proper cause, but a licensing officer also needs to consider locality of where they're at, because it's arguable that location, if you're in the inner city compared to rural New York, then you're going to see a slight change. But with that, I think that discretionary speaking, I think setting just a normal standard for self-defense being a reasonable claim for proper cause would alleviate a lot of what licensing officers have to deal with when going through applications. So hopefully that answers your question. Okay.
Eli.
So I have two questions. One, I'm not too clear. Are the licensors private or government? Okay, so then never mind on my question. Well, actually, I guess this still works as a question. What do you think about if instead of the licensors getting to make those decisions on themselves and using their discretion, it goes to the state, and now that the state is the one who gets to have that discretion, and the state is the one who gets to make that decision about whether or not you get the license?
For those zooming, Mr. Greenleaf answered the question that it was governmental entities, not private, that were doing the licensing.
Let me think about it really quickly. So government because these licensing officers are part of the government, their job is to regulate and to, make sure that not everybody's just obtaining a license, compared to, as I said, Washington, which is a shall issue. You're not required to have a certification of like 4 hours of firearm safety and insert, so you can obtain a concealed carry in the state of Washington much easier than the state of New York. So I think in the case of the state of New York having more regulation or more control on what what a submission or an application needs to look like directly from the state, or the state can set the standard, as kind of what she brought up, set the standard for licensing officers to follow. That way, the state is in control of what is and isn't allowed. So then there's some control in firearms regulation, and as well as licensing officers don't necessarily have to go and ponder too hard. It either is a reasonable, proper cause, or it isn't. So hopefully that answers your question. Okay.
Are there others? Another round of applause, please, for Dawson Greenleaf. Can I please have the stage Katherine Denison with an attending round of applause?
Sounds good. Perfect. Thank you.
Okay, so this is Katherine Denison. Trust me, I'm a doctor. Prescriptions and professional legitimacy in contemporary medicine. One more round of applause.
Thank you. Again, my name is Katherine Denison, and today I will be presenting on Supreme Court case Ruan v. United States. And trust me, I'm a doctor, prescriptions and professional legitimacy in contemporary medicine. This case involves 3 doctors and their prescription of controlled substances. To fully understand the weight of this decision, we must first take a look at a brief history of the opioid epidemic within the United States. In 1971, President Nixon declared a war on drugs, and there was an increase in the regulation of these substances. In that same year, the Controlled Substances Act went into effect. In 1995, oxycodone, one of the most prescribed controlled substances, became FDA approved, but drug companies downplayed the addictive qualities of this drug, and it wasn't until 2001 that there was an increase in consumer warning about the potential for misuse and abuse of this drug. Despite continuing efforts, the opioid epidemic continues to grow in severity. From 1999 to 2020, overdoses have increased 500%. And between 1999 to 2019, 247,000 people have died of an overdose involving a prescription opioid. There we go. So why do we continue to use them? We understand just how dangerous these substances can be, yet they are continually prescribed. One of the main uses is pain management, whether that be end of life, post-surgical, acute, or chronic pain. Studies are showing that individuals dealing with chronic pain are twice as likely to report suicidal ideation or to complete suicide. So there is a need to be treating these patients, to be treating their pain, but it's up to the discretion of the physician to weigh the benefits against the potential for the harm of the use of these drugs. So then the question becomes, how much is too much? The first two doctors involved in this case are Dr. Ruan and Dr. Couch. They were both pain management specialists operating out of Mobile, Alabama. They owned a clinic with a connected pharmacy. In 2016, they were indicted with the unlawful distribution of controlled substances, racketeering conspiracy, healthcare fraud conspiracy, and wire fraud conspiracy, with Dr. Ruan additionally being charged with money laundering in the conspiracy to commit money laundering. The third doctor is Dr. Khan. He was also a pain management specialist. At the time relevant to his indictment, he was licensed to prescribe in both Arizona and Wyoming. He was indicted with the conspiracy to distribute controlled substances, operating a continuing criminal enterprise, and multiple counts of unlawful distribution of controlled substances, one resulting in death. So there are two main regulations that we're looking at regarding controlled substances. The first is the Controlled Substances Act. Under this act, drugs are broken down into schedules, with Schedule 1 being the most highly regulated drugs that are seen to have no medicinal value, such as heroin and marijuana. Schedule 2 is where we find those drugs for pain management, such as oxycodone and morphine. This goes all the way down to Schedule 5, those least regulated drugs, such as Lomotil, which is used as a treatment for diarrhea. So there's a very wide range of what is considered to be a controlled substance. Also, under this act, it is unlawful to distribute controlled substances, but there is an exception made for medical professionals, provided that they are registered and that they are prescribing for a legitimate medical purpose and within the usual course of professional practice. There's also 21 U.S. Section 841A1, under which it is unlawful to knowingly or intentionally distribute or possess with the intent to distribute a controlled substance. Now, this is not the first time that we have seen physicians having legal issues with their prescriptions. In 1975, the United States Supreme Court heard United States v. Moore, in which a licensed physician was indicted under Section 841 for the unlawful distribution of methadone, a Schedule II drug. The Court of Appeals then reversed this decision on the grounds that this physician's registration under the Controlled Substances Act exempted them from conviction. In a unanimous decision, the Supreme Court reversed the decision out of the Court of Appeals, holding that the scope of the Controlled Substances Act was to allow physicians discretion in treating their patients, but it was not intended to exempt physicians from criminal conviction when their conduct falls outside of the usual course of professional practice. Now, looking specifically into these doctors, it started with a DEA investigation. In 2014, the DEA became suspicious that Dr. Ruan and Dr. Couch were running a pill mill, so they sent in an undercover agent acting as a patient seeking controlled substances. This agent was not asked about pain levels and had even told staff that he had been self-medicating with oxycodone that had been bought off the street. Despite this, he received a 90 pill prescription for roxicodone, a Schedule II drug, and on subsequent visits received additional prescriptions, some with an increased pill count. Through this investigation, they discovered the financial incentive behind why these doctors were prescribing so many controlled substances. Dr. Ruan and Dr. Couch each made $3.7 million from their clinic and an additional $550,000 from pharmacy service fees. They prescribed over 300,000 prescriptions for controlled substances, making them the top purchaser of oxycodone and morphine in the state of Alabama from 2011 to 2015. Dr. Khan had been handing out prescriptions for cash. The price of his visits was largely based upon the number of pills that would be prescribed during that visit. In 2015, he sold a prescription for 3 different types of controlled substances to a young woman, charging over $1,000. 2 days later, that young woman died of an overdose. So the jury has been presented with all the facts, and it comes down to the jury instruction. The judge delivers an instruction that was modeled after that given in Moore and rejects a proposed jury instruction from the doctors. This proposed jury instruction included that if they were acting in good faith, then they were prescribing for a legitimate medical purpose, and the jury must return a not guilty verdict. This creates a very subjective standard of what is included within a legitimate medical purpose and within the usual course of professional practice, when that standard should be an objective one. For this reason, this instruction was rejected in the trial court, and this is why the Court of Appeals then affirmed this decision. The United States continues on saying that even if there had been a flaw in this jury instruction, it would not have made a difference in this case and for these doctors because their conduct fell so far outside of the usual course of professional practice. Where should I be pointing this thing? Okay, so the doctors throughout this have maintained that they were acting within the benefit of their patients, saying they have patients who would have landed in the ER because of the immense amount of pain that they would be in had they not been given these prescriptions. This is what leads way into their good faith defense, meaning that they believe they were acting within the benefit of their patients, and they believe that they were prescribing for a legitimate medical purpose, and they believe that their conduct fell within the usual course of professional practice. Now, the jury instruction that was delivered did contain an element of good faith, but it continued on to say that if they were acting outside of the usual course of professional practice, they could still be convicted. By this reasoning, the only doctors who would have a good faith defense are those acting inside the usual course of professional practice. Doctors unquestionably acting within the usual course of professional practice generally do not find themselves sitting in front of a judge. So the good faith defense then only applies to those who do not need it. And the good faith defense is then no defense at all. And because of this flaw in jury instruction, this led to the wrongful conviction of these doctors. Now, at its core, it comes down to whether a physician can avoid conviction based upon that physician's own subjective belief that prescriptions written were for a legitimate medical purpose and fell within the usual course of professional practice. And was there a flaw in jury instruction that led to the wrongful conviction of these doctors? As with every decision, there is a balance that must be considered. On one hand, the opioid epidemic is very real, and there are thousands of people dying every year, and we want to limit the contribution that prescription drugs have into this epidemic. On the other hand, we must think of the implications that this decision will have on the healthcare community. We do not want doctors being criminally convicted for mere negligence. We also know that there are real patients in real pain that are benefiting from these prescriptions, and we do not want doctors withholding the correct treatment for their patients out of fear of criminal conviction. So there is no official decision on this case, but if the Supreme Court finds that good faith was correctly applied, then this case may be affirmed. But if the Supreme Court finds that good faith was incorrectly applied, then this case may be reversed, leading to an entire dismissal of the charges against these doctors, or it could be remanded for a new trial utilizing the Supreme Court's correct recitation of good faith. In the end, the acceptance or rejection of the good faith defense will be what separates these doctors from being drug dealers. Thank you.
Questions for Ms. Denison?
Awesome job. Thank you for presenting that. So how do you think that this case, if reversed, if the decision is reversed, will affect the good faith doctrine as an inclusion in other types of cases in the future?
The reversal of this case will set precedent. Right now, the circuits are extremely divided on what good faith means. So there are circuits in which you must reasonably believe that you are acting within the usual course of professional practice. There are other circuits where the United States must prove that they were intentionally acting outside. So this case will then be the new precedent for that.
Other questions?
If I heard you correctly, one of the things they're thinking about was the doctor's subjective belief about whether what they were doing is within the standard of practice. Is that a normal standard in medicine? Like the doctors don't have to do what's normal, but what they believe is normal?
On a smaller basis, yes, doctors do have the ability to decide how to treat their patients and decide what is the correct treatment for this patient. But on this larger scale, they're acting so far outside, but they're saying, for me, this is normal. And that turns into a slippery slope of how far you can get outside of those bounds and still say, yeah, I think it's okay, so it should be okay.
I saw a hand in the back, and then I'll come back down for a chat hand. Is there still a question? Here I come.
So you talk a lot about the usual course of professional practice, but I'm just curious how the standard is determined.
So the usual course of professional practice, there isn't like set boundaries of where that is. It's determined based upon both state regulation and federal regulation, but it also very much differs between different specialties. So you would expect a general surgeon to be handing out more opioid prescriptions than, say, a pediatrician. And so the red flag for a pediatrician would be much earlier than for a general surgeon. So it just differs, which is why it gets a little blurry.
Okay. I won't come to you then. Other questions? Another round of applause for Katherine Denison.
Thank you.
If you'll indulge me for 5 minutes, we have several people we'd like to thank for the Supreme Court panel. First and foremost, all of our wonderful presenters. Another round of applause for them. Second, Dr. Brandy Wiegers, we have had Source online the last 2 years. Transitioning back in person really is in many ways reinventing the wheel. And I can't stress enough what a wonderful opportunity this is for the students who presented and for all of us who've benefited from the presentation. So Dr. Wiegers, really a Herculean effort in getting us back in person. A round of applause for her. Our judges, I've judged Source before in the past, and I can tell you it's both a difficult thing and a wonderful thing because you're operating outside of your discipline. And that makes it difficult at times to chart the arguments being made, but at least for me, it's always been tremendous fun getting to hear about things that I don't really know as much about as I'd like. So a round of applause for our judges. Law and Justice Department Chair, Dr. Cody Stoddard, for whom no applause is deserved, but who so regularly works hard to make the Law and Justice Department visible in university events like this, and most importantly, give space and encouragement to our wonderful students to present these sorts of things. So I won't direct it, but I suppose if you'd like to applaud Dr. Stoddard, you may. Finally, this is one of my favorite days each year. FERPA exists and my boss is here, so I cannot comment on whether or not that I've had these students before in any of my classes. You might think that, but I could neither confirm nor deny that. But it's an interesting relationship because for weeks, for years, we watch all of y'all in our classes and we're encouraged by your curiosity. We're impressed by your skill. We appreciate your assignments. But today is a wonderful day when all of that shifts, when it's us in the chairs and you up here. And for those 10 minutes, we learn from you. We benefit from your knowledge, from your hard work, and from your expertise. And I always leave today feeling so very encouraged and hopeful for the generation of young minds that are cultivated here at Central Washington. Much is made of the college experience, and certainly the college experience regularly involves pizza and margaritas, and that's all a lot of fun. But really, I think it's the free exchange of ideas, thoughtful questions, brave presenters, and an inquisitive audience that makes this job the best job I've ever had or will ever have. Thank you for being here. Thank you to our presenters. This concludes the Supreme Court panel. Am I forgetting to direct people to do anything? I am here for a few minutes. If there's any loved ones you'd like to introduce me to, I'm happy to meet them. Otherwise, have a wonderful rest of your day. Thank you, Professor Devine.